Good morning, everyone. This is a regular meeting of the Liquor Control Adjudication Board. Today is Thursday, December 5th. And the time is 9 a.m. My name is Gary Murai, and I'm the chair for this board, and I hereby call this meeting to order. I'm going to start by doing a roll call. Pursuant to the Sunshine Law, members joining the meeting remotely, please indicate who, if anyone, is with you at your location. Okay, Vice Chair Liu.
Present.
Member Kaleo.
Present.
Member Kim.
Here.
And I see that Member Sanchez is appearing remotely. Robbie, is anyone in the room with you?
No, I'm alone.
And I also see Member Langford Favorito has joined us. Luann, is anyone in the room with you?
No, just me, sir.
Okay, thank you. I also note the presence of Deputy Corporation Counsel, Ms. Trenholm, appearing via Zoom. Also note the presence of Deputy Prosecuting Attorney Richard Ross, Director Lane Silva, Deputy Director Jared Kaho Hano, and Chief of Enforcement Colin Kawano. Moving on to public testimony with regard pursuant to Chapter HRS 92.6, no public testimony will be received on adjudicatory matters. Testimony will be accepted for all other agenda items. Maria, has anyone signed up to testify?
No.
Is there anyone in the room wishing to testify? Seeing no one, public testimony is closed. We'll now move on to the hearings before the board. And the first item will be the complaint and accusation number 2024-06 in the matter of the accusation against 808 OAO LLC, DBA OAO 35 Melia Gateway Place, space 8A-101 Wailea. The parties to this matter are the Department of Liquor Control and the licensee. Mr. Ross, are you representing the department in this matter?
Yes, Mr. Chair.
Will the licensee or its representative please step forward to the table? Okay. Morning, Ms. Chen.
Good morning,
Are you here on
Chair.
behalf of the licensee?
I am Stephanie Chen, appearing on behalf of the licensee.
Okay. Is your client present today?
My client is not present.
And but you have authority to act on their behalf?
Yes.
Ms. Chen, you can have the charges read in public, or you can waive the reading. What do you wish?
We can waive the reading. Thank you.
And with regard to count one, what is your plea?
My client has entered a plea of no contest.
Okay, and does your client understand that they have the right to dispute the allegations and request a hearing?
Yes.
And does your client understand that by pleading no contest, they are waiving the right to hearing where they can present evidence and question witnesses on their own behalf?
Yes, Chair.
Do you understand, does your client understand that on each count, if the board accepts your plea of no contest, you will be found guilty and the board may issue a reprimand or assess and collect a penalty of up to $2,000 or revoke or suspend your liquor license?
Yes, Chair.
And knowing all this, is it still your wish to plead no contest?
Yes.
Okay, all right, thank you. In that case, the board hereby finds that the licensee has entered a knowing and voluntary plea of no contest to count one. And the board hereby accepts your plea and finds you guilty of count one as reflected in complaint and accusation number 2024-06 against, how do you pronounce the name of this restaurant?
I believe it's oh wow.
Oh, wow. Okay.
Yes, but if you prefer, we can go with OAO. However you,
I like oh wow.
okay, let's go with oh wow.
Um, The board hereby finds, accepts your plea and finds you guilty of count one as reflected in complaint and accusation number 2024-06 against OWOW. Have all of the board members reviewed the violation/incident report in this matter?
Yes.
No one needs any more time to review. Okay, hearing none. Pursuant to section 08-102-92, paragraph 2 of our rules, the department and licensee shall be provided the opportunity to make narrative statements for the board to consider in determining what action, if any, should be taken against the licensee. Mr. Ross, do you wish to make a statement?
Yes, Mr. Chair.
Please proceed.
Thank you. This incident began on November 2nd, 2023, when Liquor Control Officer Trainee Mitchell Mathias noted an online advertisement for OWOW offering a 6-course dinner, but also offering an alcohol pairing with that dinner, where I believe 5 drinks, the advertisement is attached to the report here, were offered for a fixed price. Offering more than 2 drinks for a fixed price is a violation of liquor rules section 08-101-69A1. As a result, the licensee was cited for that violation.
Okay, thank you. Board members, any questions for Mr. Ross? Thank you. Seeing no questions. Ms. Chen, you now have the opportunity to make a statement regarding this case. You may also inform the board of any mitigating circumstances to consider regarding the penalty and sentencing. Go ahead.
Thank you, Chair. And thank you, board members, for your time today. I'd like to begin by acknowledging on behalf of my client that the mistake was made and that my client understands the importance of adhering to all rules and regulations. We thank you for your time and consideration of this matter. I also appreciate the opportunity to explain on behalf of my client and provide more information and context. Though not allowed under the Liquor Control Commission rules, food and alcohol pairings are not an uncommon practice in the industry. We understand and acknowledge that it is ultimately the licensee's responsibility to know and abide by the rules. However, in this case, the licensee mistakenly believed that the omakase menu that included the food and alcohol pairing was permitted. I would like to mention that OWOW has made good faith efforts and has taken corrective action to prevent the violation from occurring again. Such measures include strict overview and quality assurance implemented by management to ensure that all marketing, promotional, and digital material adheres to the Maui County liquor laws. For example, OWOW is requiring marketing management to read and understand the rules. OWOW is also requiring implementation of a 2-factor approval stage between 2 members of management and or ownership to review and approve any additional marketing campaigns or promotional materials to ensure that any menu offerings adhere to the Maui County liquor laws. And finally, the concept of an omakase menu that offers the food and alcohol pairings has been deleted in its entirety from the restaurant's marketing plans. All alcohol will be charged individually per Maui County liquor laws. I would like to mention that my client has a clean track record and is committed to compliance. We understand that to date, this is the first and only violation for OWOW. I would also like the board to note that the imposition of a large fine amount will have a significant impact on the restaurant. Chef OWOW is currently undergoing a rapid expansion with thinning available capital. Due to the approximately 30 to 40% decline in tourist business, which is the main target demographic in Wailea, business has slowed down significantly. And the imposition of a large fine will hinder the expansion efforts and affect the business's current operations. So in conclusion, my client and their staff respect and acknowledge the importance of abiding by the liquor control laws and regulations. We would again like to mention that though it is the licensee's responsibility to know and understand the rules, and though the food and wine pairing is not allowed under the rules, such pairings are not an uncommon practice in the industry. And indeed, we would advocate for a future amendment to the rules to allow for such pairings. But considering, we're at the hearing to discuss the current violation, since this is my client's first offense since obtaining the liquor license, we're asking the board to consider imposing the minimum fine amount. My client is again committed to ensuring that such violations do not occur again. The minimum fine amount would still serve as a deterrent while being proportionate to the severity of the violation. And given the circumstances, the minimum fine would strike a balance between upholding the rules and recognizing the corrective actions already taken and allow my client to continue expanding his business as appropriate and maintaining current operations. Thank you.
Thank you. Members, any questions for the licensee?
I have questions, but go ahead first. Anybody, Robbie or Luann, you want to go first?
I'm okay, thank you.
Robbie?
Robbie, you already
I
should.
got no questions.
Okay,
Go ahead,
okay.
Vice Chair.
And first of all, how long has WOW been in business?
I would have to consult with OAL to give you a specific answer.
Because the citation was written in November 2023.
Right.
So how many years prior to November 20, or months or years?
Again, Vice Chair.
I may be able to answer that.
Oh,
Hi, Stephanie. So I don't know if you realize I'm here. Hi, I'm Christian. I'm a representative of WOW. We've been in operation for 2 years now.
Didn't even know he was present.
Yeah, hold on. Well, I would ask Ms. Shin to confirm, is that the client?
Christian?
I'm so sorry. Was I not supposed to interrupt?
Oh,
You're not supposed to interrupt.
My bad. I'll say something now.
Okay, well, you already told us what the Vice Chair wanted to know. In the future, though, if you want to communicate with the board, do so through your counsel.
Or we'd have to swear him in as a witness. Hi, this is Christy.
Yeah.
Well, we're
Oh,
not,
okay. I understand now. I apologize.
okay.
Oh.
I'm sorry,
Sorry, what was the answer? Sorry.
it's 2 years.
2 years. So you're talking 2020, the WOW has been in business since 2021, correct?
if that is what Christian stated, then yes.
What's
2
Christian, I'm
years.
sorry, what's Christian's last name?
Christian Gallopon, and
Gallopon.
I apologize, board. It appears that my client is present via Zoom and is open to questions as well.
Okay, thank you. Mr. Gallopon. and
Oh,
Mrs.
just before you continue questioning, Chair, can you swear Mr. Gallopon in?
Yeah, and Mrs. Gallopon, if you have video capability, would you turn on your video, please?
Yes, give me a second.
Chair,
Yes.
just let you know Luann has her hand up,
Oh, okay.
but she has a question.
Well, okay, Member Langford Favorito, did you have a question?
Actually, no, I did look them up on the DCCA business registration, and from what I see here, they were registered on May 20th, 2022. If this is the exact same business, 808 Wow, LLC.
We'll get that information from the licensee. Thank you.
Thank you.
Okay, Mr. Gallopon, is that you? Okay, Is there anyone else in the room with you? Okay, will you please raise your right hand and repeat after me? Or do you swear or affirm that the testimony you give today will be the truth, the whole truth, and nothing but the truth?
I swear.
Thank you. Okay,
Is that
go
a-
ahead.
I'm sorry, Mr. Gallup, I didn't know you were present in the via Zoom, so good morning. So now that I know the business has been in effect since 2021, is that correct?
So yes, I ca- I counted it since we opened on November 8th, 2022.
So roughly a year before this offering, correct?
Roughly, yes.
Okay, so how long has this particular omakase offering been going on? I know you were cited on November 2nd, 2023, but prior to that, how long has this been offered? How long has it been on the menu?
The omakase itself never had any alcohol pairings prior to this offering.
So,
Mainly because we didn't have a license at the time.
okay, so when, maybe my question, I misstated it. When was this offering first available?
Offering was first available when that first ad had been pushed out.
So November 2nd, around November 2023, correct?
Yes.
Okay, so you said your marketing team vetted this before you folks put this out for advertisement?
No. So our bar manager had proposed the offering, and basically it went through the team. We were like, okay, this sounds like a good idea to offer our customers, and so we had moved forward with that project. Now, at the time, we weren't aware of weren't exactly aware of this rule that we're not supposed to promote more than 2 drinks for one price. And so I do apologize, ma'am, for the ignorance and the lack of understanding of laws, and I do regret moving forward that project. Not, but now that I do know or am aware of it, I personally make sure that we are in adherence to all codes of liquor law now with all promotions.
But I take it your bar manager's experience, correct?
That was the impression at the time, yes.
You folks don't vet your employees. I'm sure your bar manager, to get to the rank of bar manager, must have some experience in the liquor field or with the rules and regulations.
Yes. That was the assumption. He was boasting roughly 8 to 10 years of managing a bar, which was why we had trusted that this project was in accordance to it. Said bar manager is no longer employed with 808 Wild LLC.
Because of this incident?
Among other incidents that I believe I don't think I should disclose just because those are his
That's
goals and private.
I didn't expect you to do that, but I'm just wondering with a bar manager's experience with 8 to 10 years, and obviously you hired your team, why this particular regulation wasn't vetted ahead of time?
Um, so this bar manager we personally knew, and namely his name was Kevin Lockett, so we went through his resume, we went through all his we went through like a basic background threat. We also talked to all his references, and we were made confident in his ability to manage our bar.
So it was not vetted, correct?
Um,
Good idea. The bar manager proposed it. The team thought was a good idea, and then you folks went ahead and went ahead with this particular pairing. Is that what happened?
yes,
When was it finally pulled after November 2nd, 2023?
the day the citation was provided.
Do you know how many pairings how long is omakase, how many actual dinners you sold with this particular ad in effect?
So the ad itself was connected to a system in which the customer could book directly. Since we had taken down the ad and the system to book, we didn't exactly sell omakazes with the pairings.
So none at all?
That I am aware of, unless a server had sold one, which I can check right now.
So you don't know how many pairings were sold under this particular ad? You can't tell me. Can't give me a figure.
Off
Um,
the top of my head.
Judge Liu, if I may, Christian, am I correct that the citation, the notice of violation was issued, prior to the event occurring?
Um, I'm assuming the citation was for the advertisement itself and not the selling of the alcohol itself.
That was my understanding, but perhaps the
I'm sorry to interject, but according to this, the evidence, this was a new, was this like a new year? Oh, no, it just says wow year.
Yeah, not new.
Okay.
Yes, it was meant to be sold on November 8th of 2023 for our 1 year anniversary.
And Mr. Chair, that is reflected on the menu here.
Okay.
It shows November 8th to the 14th.
Yeah, it's
Oh,
kind
oh,
of
right.
like, yeah, you can
My
see,
yeah, my
yeah.
copy is really like.
okay.
Yes.
Vice Chair, do any more questions?
Okay, so you said your marketing team is now more in tune with the rules and regulations?
Yes, I've downloaded chapter 101 and 102, and basically any campaign we promote that does adhere to alcohol and liquor, we make sure that we are at adherence to that laws. Also, we do consult with Craig Nakamura as well as Joe Tanaka as well to see if any promotions that we do want to do, kind of is vetted and is appropriate in adherence to liquor law.
I appreciate that. I just want to know why it wasn't done before this ad was put out.
It's, for a lack of a better term, liquor law we see is that a lot of it is common sense. I mean, oh, you're not supposed to leave the premises with a bottle. You're not supposed to overserve someone. If someone leaves the premises while drunk, we're liable for that. This and omakazes are, well, we've seen industry practice has been usually you pair it with each course, and a tiny little or 1.5 ounces for sake, 5 ounce serving of wine. We were not aware of that rule that promoting the excessive use would have been a violation. And it is entirely, of course, on us, and we regret that we were not aware of that issue at the time, and hope that in the future that we may be able to leverage the wisdom of the Liquor Commission, as well as in using strict processes to make sure that this does not happen in the future again. Personally, I will be making sure that we do, and I regret that this situation was a product of my own ignorance.
Thank you.
Members, any more questions for the licensee? Or Ms. Chen? See,
No.
I have a question, and I'm not sure we can confirm this, but Christian, I heard you say that, well, as I'm looking at this menu, that was item 1 as far as the evidence goes. It looks like the first 3 pairings are sake. I see Hakushika, Junmai, Taka, Tenjin, Sword of the Sun, and the Dasai 45 Junmai. Those are all sakes, right?
Those are all sakes, correct?
As you said, those are 1.5 ounce pours.
Yes, they're going to be tiny 1.5 ounce shots.
And the wine pours, Whitehaven is a wine, right?
That's correct.
And Louis Martini is also a wine.
That is correct.
So it's 5 ounces each. So the total beverages were what, 14.5 ounces, 1.5 for the sake, 5 ounces for the wine.
That's correct.
Okay, thank you. But I don't know if you actually did the omakase dinner, but what amount of time does it take to for a patron to, from start to finish with this 6-course dinner?
It should take roughly an hour and a half.
Okay.
We try to pace each course
Okay.
so that we don't overwhelm the customer.
Yeah, okay, thank you. I don't have any more questions. Members, any more questions on this part of the seating? You seeing none? Mr. Ross, what is the department's recommendation as to the penalty for this matter?
Thank you, Mr. Chair. I just, to address a couple things that came up. The department pulled the blue card for this licensee, and their liquor license was issued on July 25th, 2023. So
Okay, thank you.
And as far as the department, this is a charge based on the offering or the advertisement. The department is not aware of any actual sales based on this promotion, just so we're clear on that. The department's recommendation, and to address one thing Ms. Chin said very briefly, that this is a common practice to do these tasting menus with alcohol. I think that does occur from time to time, but as the board is aware, the department regularly charges licensees with that violation. The Maui Country Club and Merriman's were both recently charged with that violation. So yes, it does occur, but the department consistently enforces this rule. With all that in mind, the department's recommendation for a penalty is a $500 fine with $250 suspended for 1 year on the condition of no similar violations.
What's the maximum for this?
2,000.
Thank you.
Okay, anything further, Mr. Ross?
No.
Ms. Chan, I know that you had alluded to a recommendation as far as penalty. Do you have anything further to add with regard to the licensee's recommendation as far as what penalty would be appropriate?
Oh, Chair, the licensee's recommendation?
Yeah.
Yes, the licensee is requesting the minimum fine amount that the board considers appropriate. As
Okay.
yeah, as stated, my client acknowledges the mistake that occurred
Okay.
and will take steps to do better, but request the minimum fine amount.
Can I just ask one more question, Mr. Gallipon? I'm so sorry. How
Sure.
many people, Mr. Gallipon, was this event supposed to hold?
The maximum capacity here at the restaurant is 80 seats at a time, so 80 people.
Okay.
Yes, and it's also dependent on who want the omakase, of course, too. So it'd be a bit hard to say how many people would have been interested in this omakase.
Thank you.
Okay, unless there's anything further from anyone, I will now entertain a motion to go into closed session for the purpose of deliberation on matter 2024-06.
Chair, Mr. Chair,
Second.
I'll second.
Okay,
Either way.
moved by Vice Chair Lu, seconded by Member Kim. Okay, a motion has been made, and I'll now call for the vote. I'm going to do a roll call vote. Vice Chair Lu,
Yes.
Member Kaleopo,
Yes.
Member Kim,
Yes.
Member Sanchez,
Yes.
Member Langford Favorito.
Yes.
Okay, the vote is unanimous. At this time, will everyone except the members please exit the room during our deliberation? I'd like to call the meeting of the Liquor Control Adjudication Board back into open session. Time is 9:47. And I will note the presence of Vice Chair Lu, Member Kaleopu, Member Kim, Member Sanchez, and Member Langford Favorito. Chair is also present. Also, I note the presence of the parties and staff. At this time, Chair will now entertain any motions by the members with regard to penalty.
Chair,
Yes, member Case.
Time on complaint and accusation number 2024-06. I move that we impose a fine of $1,000 for that violation, suspend 750 on the condition that there's no further violations of the liquor rules and regulations commencing today
For a period of 1 year.
for a period of 1 year.
Okay. There is a motion and member Kim, yes, understand it is for $1,000 fine with $750 suspended on the condition that there be no further violations for 1 year effective today.
Correct.
Any second?
Second.
Seconded by member Kalayopu. Members, any discussion on the motion? Nothing from you, Vice Chair Liu? Thank you. In that case,
I put my piece in the executive session.
at this time, I'm going to call for a vote. We're going to do it by roll call. All those in favor of the motion, say aye. All opposed, say nay. Vice Chair Liu?
Nay.
Okay, member Kalayopu?
Aye.
Member Kim?
Aye.
Member Sanchez?
Aye.
Member Langford Favorito?
Aye.
And chair votes aye. Motion carries by a count of 5-1. Motion, and therefore the motion passes. Ms. Chen, your client will be notified when payment is due.
Thank you. Thank you, board.
Okay, moving on. Next matter. Next matter will be agenda item number 4B, complaint and accusation number 2024-10. In the matter of the accusation against Macadangdang Group LLC, DBA Joey's Kitchen, Apili, Maui, Hawaii, restaurant general category BII, license number 195. The parties to this hearing are the Department of Liquor Control and the licensee. Mr. Ross, are you representing the department?
Yes, Mr. Chair.
Will the licensee or its representative please step forward to the table?
Good morning again, Chair, Vice Chair, and members. I'm Stephanie Chen, appearing on behalf of the licensee, and my client is present.
Good morning, everyone.
Please identify yourself.
My name is Virgilio Macadangdang, nickname Joey.
Thank you. Ms. Chen, you and your client can have the charges read publicly. If you don't want to, you can also have the charges, the reading of the charges waived. Which do you prefer?
We wish to waive reading of the charges. Thank you, Chair.
And Ms. Chen, as to count 1, permitting liquor to be removed from the premises, how does your client plead?
My client has entered a plea of no contest, Chair.
You know, I'm sorry. I jumped ahead of myself. I forgot to do my elocution. Oh, no, I'm sorry. I'm okay. Yeah. But as to all of these pleas that you intend to enter, Ms. Chen, does your client understand that he has a right to plead not guilty?
Yes.
And he understands that by pleading no contest, he will be waiving his right to hearing, which he could present evidence and question the witnesses on his own behalf.
Yes, that's correct.
And is his plea of no contest voluntary and not the result of any threats, coercion, or promise apart from the plea agreement?
Yes.
And do you understand that if the board accepts your client's plea of no contest, you'll be found guilty and the board may issue reprimand or assess and collect a penalty of up to $2,000 or revoke or suspend the liquor license?
Yes, Chair.
And is it still your wish to plead no contest?
Yes.
The board hereby finds that the licensee has entered a knowing voluntary plea of guilty to counts 1 and
No contest.
I'm sorry, no contest. Thank you, Mr. Ross. Ms. Chan, what is your client's plea as to count 2, which is a failure to obtain a production or permit for increasing licensed premises?
No contest, Chair.
And as to count 3?
Mr. Chair, count 3 is being dismissed pursuant to the plea
Oh,
agreement.
I'm sorry, Mr. Ross. So the plea is only to counts 1 and 2 or just count 1?
Counts 1 and 2.
So count 3 has been dismissed. Okay. And Ms. Chen, as to count 2, the same questions would apply. That he understands he can contest that as well.
Correct.
Okay. The board hereby finds that the licensee has entered a knowing and voluntary plea of no contest to counts 1 and 2. The board accepts the plea and finds you guilty of counts 1 and 2, as reflected in complaint and accusation number 2024-10 against Joey's Kitchen. And I also note that count 3 has been dismissed. Have all the board members reviewed the violation and incident report to this matter?
Yes.
Okay, thank you.
Yes.
Thank you. So no one needs additional time to review. Pursuant to section 08-102-92, paragraph 2 of our rules, the department and licensee shall be provided the opportunity to make narrative statements for the board to consider in determining what action, if any, should be taken against the licensee. Mr. Ross, you may proceed with the statement.
Thank you, Mr. Chair. On February 13th, 2024, LCO Martin Davis, on inspecting the premises of Joey's Kitchen, discovered the premises had been modified from the floor plan on the attached to the liquor permit. There were 2 new openings, essentially an opening behind the bar and double doors from the dining room, both of which led into an adjoining unit, which is not included on the liquor permit. There's a diagram of the unit showing the area that had been expanded into, which is not included. LCO Davis also noted that there was liquor in the adjoining unit. There was no indication that it was being used for service of liquor, but liquor was definitely being stored there. There's photos showing that. So that resulted in the notice of violation here. Count 1 being the removing liquor from the premises because the adjoining unit is not considered part of the premises. Storing liquor there constitutes removing liquor from the licensed premises. So that's the basis for count 1. Count 2 is based upon the fact that the licensee did not obtain a permit to make changes to the licensed premises, which they're required to do under section 08-101-2785. So on that basis, so that's the basis for these charges.
Thank you, Mr. Ross. Members, any questions for Mr. Ross?
So there was actually 2 inspections, correct? One on the 9th and then one on the 13th.
Yes.
Correct. That's all there's, unfortunately, there was a typo, it's 12/9/24, but obviously that's after 2/13/24. So I'm assuming that's 2/9/24.
I believe so, yeah.
First inspection 2/9/24, second
Yeah.
inspection 2/13/24. So 4 days later.
I don't know if there was 2 inspections or if that's just a typo. There was only
Right.
1 inspection.
Was his initial and then second.
Right,
So
yeah.
they're 2
That's-
different days, 4 days apart.
I believe that appears to be correct, yes.
Thank you.
Members, any further questions? or Mr. Ross? Okay.
No.
Seeing none at this time, Ms. Chen, you now have the opportunity to make a statement regarding this case. You may also inform the board of any mitigating circumstances you wish the board to consider regarding penalty and sentence.
Thank you, Chair, and I neglected to say good morning again to the prosecuting attorney in the department, excuse me. Also to Deputy Corporation Counsel Trenholm. So to begin here, my client would like to acknowledge the error in judgment by violating the liquor code provision and storing the alcohol in the extended premises, which was not part of the licensed premises according to the current permit. My client regrets the mistake and understands the importance of adhering to the rules and regulations. And we thank you for your time and consideration of this matter. We appreciate the opportunity to come before you to explain the factors that led to this situation concerning Joey's Kitchen. Unfortunately, the liquor control inspector's findings are largely reflections of the disorder that resulted from the Joey's Kitchen emergency response to the August 8th, 2023 Lahaina wildfire disaster. As you may be aware, Joey's Kitchen was acutely affected by the fires. Upon evacuating from their home on the night of August 8th, Joey and his family arrived at the restaurant and immediately began preparing food for wildfire evacuees, survivors, and first responders. This effort continued for nearly 1 month. The restaurant premises underwent dramatic reconfiguration to meet the rapidly changing needs of the community as part of this emergency response. Goods and other commodities had to be moved and relocated to accommodate the restaurant's efforts to feed the community in the wake of the fires. Joey estimates that 12 to 20 staff volunteers provided around 8,000 hours of labor, and that the restaurant provided approximately $80,000 in meals to the fire-affected community free of charge. I would like to highlight that Joey's Kitchen has made good faith efforts and has taken corrective action since the violation to prevent it from occurring again. For example, Joey's has closed off the unpermitted space and has placed the alcohol in a locked storage unit in the permitted area. Further, Joey has instructed the bar manager to only store liquor in the permitted area. Joey's is also currently working with the liquor department to extend the licensed premises. The imposition of a large fine amount in this case will have a significant impact on the licensee. With the reduction in tourism and with residents being forced to move off island, Joey's Kitchen has been further impacted by the fires. Indeed, the restaurant recently took out a loan from the Small Business Association to keep business afloat. Given the unique nature of this case, especially considering the fire response efforts and $80,000 in meals provided to the fire-affected community free of charge, we respectfully ask this board to consider waiver of any fine amount. The issuance of the citation and having to appear before the board will still serve as a deterrent. Waiver of the fine, given the circumstances, would strike a fair balance between upholding the rules and recognizing the corrective actions and community service measures already taken. Waiver of any fine would also allow for maintenance of the premises and commitment to compliance without adding increased financial strain. In conclusion, Joey and his staff respect and acknowledge the importance of abiding by the liquor control laws. This case is unique in that the disorganization that led to the issuance of the complaint and accusation was largely the result of Joey and his staff's heroic response efforts to the fires. Given the unique circumstances here, we are asking the board to consider waiving any fine. My client is committed to ensuring that such violations do not occur in the future, and we are open to any questions. Thank you.
Thank you, Ms. Chen. Members, any questions?
How big is the neighboring unit?
800 square, 600 square feet.
I'm sorry. Square meter.
Yeah. If,
I don't know who's answering this.
Mr. McAdee, you know, would you, I'm going to swear you in right now. Would you please raise your right hand Do you swear or affirm that the testimony you give today will be the truth, the whole truth, and nothing but the truth? Yes. Thank you. Go ahead, you can answer the
I'm
question.
sorry, how big is the name
600 square feet,
and how big is your regular restaurant area?
1600.
1,600. And when did the two openings get cut into the neighboring?
That was 2022.
When in 2022?
2022, we renovated the area and then we closed it.
No, you cut the two openings to go
Yeah.
into the neighboring. So when would the two openings cut into the neighboring area?
No, yeah, that was 2022.
20.
When we cut it and then we sealed it,
Okay.
during the fire, we opened it up.
So why did you cut it in the first place?
We wanted to join and file a permit.
Okay, so you cut the openings before you had the permit to enlarge the space.
Right.
And why did you do that?
Because I thought that would be, at the time, I think we'll be able to get the permit. We did.
Okay.
And sorry, Judge Liu, so my client, as I understand, created the opening, started the application process for the permit to extend the licensed premises, and then was made
After the
aware,
openings.
and then became aware that that was not allowed, sealed off the openings, and please correct me if I'm mistaken, Joey. Sealed off the openings, the opening pending receipt of the permit for the extended licensed premises, which has been, there has been a lot of back and forth with the department on this. And we're still not in possession of that permit for the extended premises, but we are actively working with the department on that, but it has been in progress.
The openings were cut in the anticipation of getting this permit.
That is correct.
Okay, but when the openings were cut, you did not have permission to expand
That's correct.
into that area. But you had the landlord's permission to cut into that
Yes.
opening.
Yes.
So once you cut into the opening, at some point you were storing liquor, bottles, boxes.
The liquor, and correct me if I'm wrong, Joey, but the liquor was stored in the extended premises, which are not part of the permitted area. The liquor was stored there as a result of the Lahaina wildfires, when things needed to be moved around to accommodate the influx of people seeking food. So as I understand, things were moved, liquor was moved. It was never served in that extended premises. It was
I
just,
agree. I'm not
just
saying
stored.
that, but for the pictures and from the
Right.
report, there's that your wife or some employees at one point were eating in there, so using it like maybe a break room or something like that. And the LCOs were able to see the used bottles, right? So obviously someone had used these glasses. I'm not sure if they were dirty or clean. I can't tell from the report, but obviously glassware or something for the restaurant was kept in this area as well. Is that correct?
Those are catering glassware. that-
Okay, so catering glass, then we had bottles, like used bottles were also being kept there. And then I don't know if they were empty boxes or boxes that had liquor in them, because obviously they had names of liquor on them. So this space was being, I guess my point is that this space was being utilized in whatever fashion folks decided to use it in. I'm saying serving liquor.
Right.
And it was being used without the proper permits. Is that right?
That's correct, Judge Liu. And again, I mean, we acknowledge the error in judgment, but would like the board to note that the error in judgment, was largely a result of the disorganization, disorder that ensued in the wake of the fires.
Okay,
Yeah.
but this process was started in 2022, which is prior to the fires.
Correct. The opening was started in 2022. And the permit to extend the licensed premises was also started then. But the storage of liquor was not taking place in the extended premises prior to the fires.
You say only after the fires it was stored in there,
Correct.
which is still not correct. Whether it was before
Right.
or after, still not correct.
It's still a violation of the rules.
And then I know Joey's Kitchen has been around a very long time, right? That particular restaurant's been in effect since
2060.
2016. So seven-ish, 6-ish years before this whole incident. well. Okay. Somebody else can ask questions.
Okay.
I think I'd answer.
Any other questions from any members? No. Okay, you? Mr. Ross, what is the department's position as to the penalty for each count?
Thank you, Mr. Chair. The department's going to recommend a fine of $500 on count one and a fine of $1,500 on count two with $750 suspended for 1 year on the condition of no similar violations. The department's concerned that this modification continues to exist. And then perhaps the director can address this, but my understanding is that there's not an active permit modification application before the department. Is that
Has
correct?
there ever been one?
Yes, that is correct. There have been attempts to submit a permit request to have that done, but I do believe at this current time, there is no current request in the department. And I'm waiting for a response as to when the last time an attempt was made at submitting a current request for that.
If I may.
Ms. Chen?
So it's my understanding that in 2022, Macadang Group LLC had applied for a liquor license that would have covered the extended premises in question. I further understand that the application was submitted to the liquor department, and this may be what you're referring to, Director. But that upon request for a status update, the department was unable to locate that application. The request for the status update occurred in 2023, in June of 2023. And I understand that since then, our office has been actively corresponding with the department to try to work out the final details for the application, but that one had been submitted in 2022. Is that correct?
I cannot speak to the accuracy. All I can tell you is I do know that there was an attempt made, a request made. I believe there were corrections that were asked for. And as far, I'm not really sure how to define actively working with the department, because it's my understanding that it's been quite some time since there has been any interaction regarding that permit request.
Oh, okay, because I've been copied on some emails between our office and the liquor department requesting appointments. So I'm happy to discuss this offline and try to work out the details, but for the board's purposes, please note that we are actively seeking extension, of the licensed premises, and we will work with the department on this.
See, Director, so I'm not sure who the best person to answer this would be. What I gather from what I'm hearing right now is that this 600 square foot additional space still exists. The doorway still exists, but it's not being used for serving or storing liquor.
Well, what I can respond to that is my understanding is that the area has been blocked off and it's not being utilized. I cannot tell you what is taking place on the other side of the sealed entry or whatever the access. I think that's really all I can respond to that at this time.
Ms. Chen, is my understanding correct that this space is still being used, it's just not for serving or storing alcohol?
Thank you, Chair. So it is correct. The director is correct that entryway, that connecting space has been sealed off. There is no alcohol being stored in the extended premises, and it is not being used for the service or sale of any alcohol. I'll ask Joey to explain what it's presently being used for, since he's there on a day-to-day basis.
Mr. Macadang.
Yes, sir. So the only things that's in there is tables, rubbing machine, and office. And then some canned goods that use for the restaurant, but there are no alcohol, any of that.
And you don't use it to serve
We don't
food
use,
either.
it's sealed off with, the windows are blocked off with paper, so you can't see inside.
Like follow up with that.
Sure, go ahead.
So it is not being used for purposes of serving alcohol, but the space is being utilized.
Utilized as office,
So it is being used.
yes.
And when I'm sorry to jump back, but when one of the inspectors came, one of the employees did move a plyboard sheet over the openings to kind of block it off. Is that correct?
Yeah, that's what we
Report.
put the seal on that.
I know, but when the inspector came, somebody literally walked a piece of plyboard over the opening so you couldn't see behind, according to the report. Is that what happened?
Possibly, Judge, because I wasn't there at the time.
And Judge Lou, I wasn't there either, but it may have been an attempt to remedy the violation as quickly as possible to prevent people from going in and out, but I was not there.
Feel the LCO from seeing inside,
Wow.
Again, I was not there.
and neither was I.
Mr. Chair, I have a question for the department.
Yes, Mr. Kim.
So whenever a licensed premise expands or attempts to expand, they have to go through the commission to get before they can actually occupy that space.
It's not necessarily that it would have to go through the commission. It depends on the way the requirement is on a substantial increase, that the commission would then have the authority to decide whether additional property owners or lessees within a 500-foot radius would then
Actually, fall into the,
fall in and would need to be notified or not. And that would be on the whether or not it was considered a substantial increase. Other than that, those permits can also be approved in the department.
okay, so the department does have the discretion, if it's not a substantial increase, that there would be another extra space for the licensee.
Yes.
Okay,
Yes,
and in this case, specific case, the 600 square feet, would that be a substantial increase?
That's 1/3, over 1/3.
but see, it depends
No,
on how
because
you
of the
derive.
footprint, right?
Yes, it depends on how you derive or come to that 600 square feet, because if it's a situation where you end up moving 10 feet over this way and the
Yeah.
amount of, what we'll look at is how does it affect the existing 500-foot radius and the notifications, and how many new properties are affected by the increase. That's kind of the formula we use to determine if it's a substantial increase or not.
Okay, and hypothetically, if a licensee stores their alcohol off premises, does the commission or the department have to look at where those extra cases are stored?
Yes, in order to store liquor off of the licensed premises, there is also a permit, liquor storage permit that would allow for liquor to be stored elsewhere. That particular permit is typically used by the touring cruise type licenses, the tour boats, where they don't have a whole lot of storage on the vessel itself, so they store elsewhere. There is a permit that exists that would allow for that.
Okay. Thank you.
I have a question for the director. Director, if a licensee, the department's Juliana is just a licensed premises. Hypothetically, if a licensee wanted to say build a storage shed for their cleaning supplies, that's not your Juliana, is it?
It's not.
Okay, so they can do, make improvements, and as long as there's no intention to make that a serving or storage area, they can just go ahead.
I think a good way to answer that question is that the department's jurisdiction lies within the licensed premises. If they're storing tables, silverware, office space, whatever it may be, in an off-site location, the department's jurisdiction falls within the licensed premises.
Okay, thank you. Okay, if there's no further questions from the board members, at this time, Mr. Mr. Ross, what is the department's, I'm sorry, you already did that. I'm sorry, okay.
Sorry, I didn't completely understand. It was $500 fine for the count one.
Yes, $500 fine for count one, and count two, the department,
Suspend 750.
that's correct.
So 1,500 for count two and suspend 750 for count two.
Correct.
Okay. At this time, Chair will now entertain a motion to go into closed session for the purpose of deliberation on complaint and accusation 2024-10. Who'd like to make that motion?
Second.
Moved by Member Kim, seconded by Vice Chair Liu. Any discussion? Seeing none, I will now call for the vote. I'm just going to do aye or nay. All those in favor of recessing regular session and going to executive session, please say aye.
Aye.
Yes.
Aye.
Any opposed? Hearing none, motion carries unanimously. We are now in recess. It is 10:18 a.m.
You're gonna go into deliberation, not recess.
Right. Well, we're recessing our regular session and I'm calling our executive session to order. Board is now back in open session. It is 10:32 a.m. And we are back in session on complaint and accusation number 2024-10. I'll now do a roll call. Vice Chair Liu,
Present.
Member Kaleopu,
President.
Member Kim,
Present.
Member Sanchez,
Present.
Member Langford Favorito,
Here.
and Chair is also present. At this time, I'll entertain any motions with regard to penalty.
Mr. Chair,
Yes, Mr. Kim.
at this time, after considering all the facts and circumstances under complaint and accusation number 2024-10, I move that we, on count one, we fine the licensee $2,000, and on count two, fine the licensee $2,000.
Okay, it's been moved by Member Kim that penalty be $2,000 for each count. Is there a second?
I second.
Oh, go ahead.
Okay, seconded by Member Favorito. Any discussion?
Well, the motion that I made was in consideration of the 2019 violation as well as the timeline of when the licensee tried to or intended to expand the premises of Joey's Kitchen. And so other mitigating circumstance in between that falls outside of the timeline of their intent to expand the premises. It's all well and good that Joey's Kitchen did assist in that catastrophe of the Lahaina fires. However, taking into consideration that almost 6 months, 7 months had passed, seems to me disingenuous for the licensee to express all the assistance that he or the licensee gave to the community. In my mind, I believe they knew exactly what they were doing. Anytime liquor is licensed for anyone under the jurisdiction of the Liquor Control Board, well and good that if you're going to expand, you got to go through the steps. And the intervening circumstance of the Lahaina fire, to me, that has nothing to do with this violation. So I'm taken aback by that mitigating circumstances or what was said by the licensee. So at this point in time, I believe a $2,000 fine for each count is warranted.
Thank you, Mr. Kim. Any members, anyone else have anything to add?
I concur in Mr. Kim's comments.
Any further comments? Seeing none, at this time, I'm going to call for the vote. I'll be doing a roll call vote, and all those in favor would say aye. Any opposed would say no. Vice Chair Lu,
Aye, yes.
Member Kalliope,
Aye.
Member Kim,
Aye.
Member Sanchez.
Aye.
Member Langford Favorito.
Aye.
Okay. Okay, there are five votes in favor of the motions. Six, well,
Oh, I'm so sorry. Didn't vote.
I didn't vote. I don't need to vote in this
Okay,
because it
all right.
already carries. Motion carries. Ms. Chen, your client will be notified when payment is due. Thank you.
Thank you.
Thank you. Okay, moving on, to item number 5 on the agenda. Next meeting will be scheduled for second at 9 a.m. I realize that it's like right after the holidays, so members, please confirm whether you'll be able to make it or not. We want to make sure that we also expect a fairly heavy calendar. So if you cannot make it, please let Maria know right away. Unless there is anything, Maria, is there anything else? Okay, in that case, the orders of the day call for us to adjourn.